Actually, we have bill number 2, number 3, and also bill number 32. Bill number 2 is Constitutional Amendment Bill regarding, first of all, it was, as you know, it was moved by private members, the Honorable Paul Mwiru, and I'm sure you have it with you. We also have the Sexual Offences Bill moved by the Honorable Amoding Monica, District Human Representative Kumi. You have the bill too. And then the third one is what you found us discussing, Constitutional Amendment Bill number 3, moved by the Honorable Odurja Lutanywa. I'm happy you don't come from this part of the country, the Far East. Otherwise, you'll be very uncomfortable with these names of Oduru. But that will be for another day. So, here, let us know who is appearing with you, and then later on, the committee will introduce itself. I'm a session chair, courtesy of a very magnanimous and generous chairperson of the committee. And my name is Abdul Katund. So can we introduce ourselves for purposes of the record? We have already prayed. I know you sometimes don't believe in these things, but we have no choice. We have prayed for you.
It does.
Yeah, can you introduce your team, the Honorable Minister?
Thank you very much. First, I begin by apologizing. I could have been here 11. Coincidentally, the Speaker of Parliament had the function of receiving the election observers report, and we wanted to meet together with the chairman to be present and witness the occasion. It took a bit long, but finally we got. And we thank you for your patience. My name is Ephraim Kambutu of the Office of Justice and Constitutional Affairs. I have come with the team which I will ask to introduce themselves. The meeting will come.
Thank you, Minister. My name is Paul Okoreko, Minister of Justice and Constitutional Affairs.
Dr. Honorable Minister, Honorable Members, my name is Julia Andama.
If you may put the microphone near you such that you are quite audible.
My name is Andama. I work in the Ministry of Justice, Director of the House Parliamentary Council. I'm here to support the Minister.
Thank you. Can colleagues introduce themselves? Starting from my far left.
Member of Parliament and member of the committee. Basari Rashmani, Beginning Municipality, member of the committee. Okay, mine is out. Okay,
Did you have to mention Mwenge?
It's okay. We will pronounce it in English. We will not put Mwenge in English. It will be a different thing. Can we say the future, the incoming? Okay. Honorable Rakoji, you're most welcome. Yes.
Veronica Rabu-Chetero, Member of Parliament of the Minor County, and a member of this committee.
Jacob Obot, Member of Parliament, West Budama South, and the humble chair of this committee, but not the chair today.
Okay. The Honourable Minister, you are most welcome.
The other Bulgarians left.
Yeah, our colleagues who are a little bit head up will introduce themselves when they appear. So we have 3 bills. I don't know, for purpose of the record, are you ready for response on all the 3 bills?
Yes.
Okay, we give you an opportunity. You start with which one?
I'll start with the the way you have presented the constitutional amendment bill, number 1, number 2, number 3, and number 4. I have a written statement actually.
Okay, do you have copies for members?
Yes, if you have copies.
They don't go with them, you brought them for us.
Yes.
Clerk, can you pick and give to members? Madam, you still have more? Sorry? I thought they are consolidated in one document, the response.
Yes, they are.
And you came with only 2 honorable commentary should have, because members want to follow you.
I think all the documents, if you have,
I can
we can give you.
So the document.
Can you run one meanwhile? On this floor, can't you run one? Quite fast? On this floor.
Run copies.
Can't you run in copies? Yeah, run some copies. The other side. Me, I already have.
I clarify. I have a comprehensive document on constitution amendment bill, but I have a separate document on the sexual offences.
We have both.
We can have both, but we are going to be looking at one document.
Yes.
I thought.
I want to study.
The comprehensive,
Yes.
not sex. You want to end up with one of.
But I think taking back to sexual.
Okay.
Sing everybody else to that.
Let them run a copy for this.
The clerk is running. Clerk, run the comprehensive one.
For the 2 also.
Yeah.
This is the comprehensive.
Colleagues, as they run that document, can't we?
We can
Obviously,
proceed.
with much difficulty, but I think to save time, let's proceed. Thank you, Honourable Minister. May you proceed?
Thank you, sir. Honorable Chairperson and honorable members, this submission is in response to the letter which you brought to me, reference number AB 287/477 dated 8th February, in which the committee invited me to give a considered opinion on 3 bills seeking to amend the Constitution, that is Constitution Amendment Bill 2020, Bill number 12 of 2020, then Constitution Amendment Bill number 2, Bill 2020, Bill number 19 of 2020, and the Constitution Amendment Bill 2020, Bill number 20 of 2020. So the purpose of the bills before the committee is to amend the Constitution of the Republic of Uganda in accordance with Article 259 and 262 of the Constitution. And these bills are, as I have mentioned, Constitution Amendment Act 2000, Act number 13, 2000, Constitution Amendment Act 2005, Act number 11 of 2005, Constitution Amendment number 2, Act 2005, Act number 21 of 2005, Constitution Amendment Act 2015, Act number 12 of 2015, and the Constitution Amendment Act 2018, Act number 1 of 2018. Colleagues, we have analyzed the proposals in the 3 bills, and I wish to give the opinion of the ministry as follows. I also want to draw your attention.
Can I ask you a quick one? When you say the ministry, that includes the office of the Attorney General?
Yes.
Okay.
Yes, it does. Yes, it does. I'm just drawing the attention that your letter came suddenly, so we didn't have chance to consult all that we would have done but what we have done is on record. So, the general observations are on page 2, Mr. Chairman. Honorable members, since 2005, when the country held a referendum, the Ministry of Justice and Constitutional Affairs has received several proposals for amendment of the Constitution from different stakeholders. The proposals have been compiled and are awaiting further processing through a Constitutional Review Commission. This commission is in advanced stage of establishing by government. I can confirm to you, I had a meeting with the President on this matter last week. So it is in advanced stage. I know there has been delays. Members might be doubting whether we are politically committed to it. We are. Honorable members, during the process of enacting the Constitution, the Legal and Parliamentary Affairs Committee of Parliament, which scrutinized the bill, recommended to the House that since there was popular demand for amendment of the Constitution, government should set up a Constitutional Review Commission, process the proposals received by the committee, but which were outside the ambit of the Constitutional Amendment Bill 2015. The report of the Committee on Legal and Parliamentary Affairs was adopted by Parliament. Parliament, in adopting the report of the committee, also adopted the recommendation of the committee to set up a Constitutional Review Commission to consider all the proposals that were received, but were not considered because they were outside the scope of the bill. It is therefore, Mr. Chairman, contrary to the recommendation adopted by Parliament to select a few proposals and amend the Constitution in a piecemeal manner when Parliament recommended a methodology that would ensure comprehensive amendment of the Constitution. My ministry, in advanced stage, I have mentioned it, we are in the advanced stage of establishing a Constitutional Review Commission. We are only waiting for the certificate of financial implication from the Ministry of Finance and Economic Development. And I'm sure members, you have debated the budget framework paper. Provision for this purpose is there in that framework paper. Also, there are financial implications in what you have proposed. Chairman and members, the three bills before this committee are private members' bill. They are promoted by Honorable Mawanda Michael Maranga, MP for Igara County East, Honorable Paulo Miru, Member of Parliament for Jinja Municipality East, Honorable Odu Jack Rutanywa, MP Kibanda South. Article 93, remember, has a restriction on financial matters of the Constitution and prohibits a private member from introducing a bill that has financial implications, that has a charge on the consolidated fund. You know it only too well, Mr. Chairman, I know this. So, Bill number 12 of 2020 proposes to make several amendments to Article 161 of the Constitution to reorganize the administrative framework of the Bank of Uganda by modifying the composition of the board of the bank and providing for the appointment of the governor and deputy governor. Bill number 19 of 2020 seeks to amend Article 86, repeal Article 140, and insert a new Article 32A. The amendment to Article 86 proposes to establish election petition tribunals which shall have the jurisdiction to determine questions relating to whether a person has been validly elected a member of Parliament or a seat of member of Parliament has become vacant, or whether the person has been validly elected Speaker or Deputy Speaker or has validly vacated such office. Now, the proposed Article 32A in Bill number 19 of 2020 proposes to require the Equal Opportunities Commission submit reports to Parliament on the progress made by the state in regard to the steps taken to address affirmative action challenges and the promotion of equitable distribution of employment opportunities for any office. Bill 20 of 2020 seeks to amend the third schedule of the Constitution to include the Maragoli. This is something we have been debating as an indigenous community because they settled in Uganda as far back as the 19th century. From the provisions of the bills highlighted above, Mr. Chairman, it is very clear that the three bills, one, have financial implication, imposing a charge on the consolidated fund, and this should not be done if it is a private member's bill, and cannot be introduced as a private member's bill, because such a bills can only be introduced on behalf of government. And government, as I have mentioned to you, is proposing a comprehensive constitutional review. So our comments on specific clauses of the bills are as follows. Amendment of Article 161 of the Constitution. Clause 1A of the bill proposes to amend Article 161 of this Constitution by substituting for Clause 2 the following. The authority of the Bank of Uganda shall vest in a board which shall consist of A governor, B, 6 other members. So our response on this is simply first.
Yeah.
Yes.
Yes,
Procedure here. I have listened to the Honorable Minister, and he's saying that these bills are not properly before Parliament because they don't have certificates of financial implications. So is it necessary therefore to delve into the details of those bills, or we have first of all to agree or disagree with him on that matter so that we move properly?
in law, there is something which we call an alternative. And I'm sure your neighbor should be able to school you in it. You say I don't agree with this, but even if it were with this, then you will give the submission. The issue about these bills, they were committed to this committee by the authority of the Speaker. They must, and they were published, they read the bills, they must have satisfied all these requirements before the Speaker committed them here. We are not going to look into whether the Speaker committed these bills irregularly to our committee. That we cannot do. Our assumption is these bills are right before us. If there is any issue about that, it should have been handled in the House. But as far as the chair is concerned, they are properly before us. As to the reply, we shall reply to him. We shall handle that. He's what about this. But the Speaker has sort of sorted this matter out. If you may proceed.
Maybe on that point, because I was in Parliament yesterday, the Speaker raised a constitutional matter in amending provisions of the Constitution that it would require 2/3 to amend any of these articles.
Correct.
And given the COVID impact on sitting of Parliament, that we can hardly raise 2/3 of the members of Parliament to sit, whether this matter would not have to wait, even in its form, wait until these circumstances are changed. Maybe you were there yesterday.
Yes, I was, but that has nothing to do with what we are doing. First of all, the rules don't allow us to speculate. We cannot sit here and say we will not raise the 2/3. We don't have any basis for that. So I think let's do our job, colleagues. And if the House hits us now, so let it be. but for us, we are under an obligation to finish this job.
With much obligation, sir, I oblige. So, Chairperson and members, in response, we are responding as follows. First, the proposal seeks to remove the Deputy Governor from the board of the bank, and in our opinion, the Deputy Governor is a key to the functioning of the bank and should be private to the deliberations and decisions made by the board. Second, the proposal does not seem to make any substantial change to the composition of the board. The current Article 161(2) of the Constitution provides that the board shall consist of the governor, this is the current position, the deputy governor, and not more than 5 other persons. So that is 7. This means that the full board is made of 7 members. This is the same as the proposal in the bill. Number 2, Article 161(2) of the Constitution currently provides the flexibility on the number of the board members at a particular time. Whereas a full board is 7 members, it does not have to be at any one time. This means that the business of the board can always proceed even if the board is less than 7 members. The management of the economy is a critical matter. I'm sure members appreciate this. That should not be curtailed by questions as to whether the board is full or not. That was the reasoning of the Constituent Assembly, and it is still sound today. In any case, the bank always strives to ensure that the board is fully constituted. We come to clause 1B of the bill to amend Article 161 of the Constitution by substituting for clause 3 the following. The governor and all other members of the board shall A. be appointed by the President with the approval of Parliament, and B. hold office for a term of 5 years and shall be eligible for reappointment. We respond as follows. A review of the proposal indicates that it is similar in content to the current Articles 161(3) of the Constitution. The current provision states that the members of the board shall be appointed by the President with the approval of Parliament, and the proposal does not change that. That's what it is, and that's what the proposal has done. Like the proposal in the bill, the current provision states that the governor, deputy governor, and members of the board shall hold office for a term of 5 years and are eligible for reappointment. We do not notice the change sought to be effected to Article 161(3) by the bill. Chair, Clause 1C of the bill proposes to amend Article 161 of the Constitution by substituting for Clause 4 the following. The governor and all other members of the board shall, the President shall appoint a chairperson of the board from among the members appointed under Clause 2B. Our response? The current Article 161(4) of the Constitution states the governor and deputy governor shall respectively be the chairpersons and deputy chairpersons of the board. The amendment seeks to provide that any other member of the board except the governor and deputy governor shall be the chairperson and deputy chairperson of the board. The proposal needs to be studied further. Yes, it needs to be studied further to ascertain how it impacts the governance of the bank. We draw your attention, Mr. Chairman and members, in some countries, the chairperson of the board is the governor. In others, it is not. There is therefore need to ascertain good practices and determine the position that works for Uganda. It is not a good idea to experiment with the administration of a bank responsible for managing the economy without proper feasibility study. Clause 1D of the bill proposes to amend Article 161 of the Constitution by substituting for Clause 5 the following. The President may remove a member of the board from office, A, if information relating to the conduct of the member, which could have precluded his or her appointment, is brought to the attention of the President. B, for inability to perform the function of his or her office arising from infirmity of body or mind. And C, for incompetence. D, for misbehavior or misconduct. E, for failure to disclose at a board meeting a matter which he or she has personal interest. F, who has been convicted of an offense and sentenced to imprisonment for 6 months or more by a competent court in Uganda or outside Uganda. And G, for bankruptcy or insolvency. And H, for absence without prior notice to the chairperson of the board for more than 4 consecutive meetings of the board. The proposal seeks to introduce more grounds for the removal of a member of the board. Our proposal is that the proposal may effectively be made to the Bank of Uganda Act, which provides for detailed grounds for removal of members of the board. Section 9 of the Bank of Uganda Act provides as follows. 9. Disqualifications of directors. Number 1, no person shall be appointed or be a member of the board who is or becomes a director or a salaried office of the bank other than the governor and the deputy governor. Number 2, a member of the board shall cease to hold office if he or she becomes of unsound mind or is incapable of carrying out the duties of his or her office. B, he or she becomes bankrupt or suspends payment or compounds with his or her creditors. C, he or she is convicted of an offense punishable by more than 3 months imprisonment or is convicted of an offense involving fraud and dishonesty. D, he or she is convicted of the offense of abuse of office. And E, in the case of a person having professional disqualification, he or she is disqualified or suspended from practicing his or her profession by a competent authority or ceases to be a member of the profession otherwise than at his or her own request. Indeed, members, some of the grounds in the bill are already provided for in Section 9 of the Bank of Uganda Act. Now, when we come to Clause 2 of the bill, it proposes to amend the Constitution by inserting Articles 161A, 161B, and 161C as follows. 161A, the governor of the central bank. There shall be a governor appointed under Article 161 who shall be the chief executive of the Bank of Uganda. 2, the office of the governor shall be a public office. 16(8)(b), functions of the governor. The governor shall, this should be, it is 161B, 8 is not there. The governor shall, number 1, be responsible for monetary policy, have authority to incur expenditure for the bank within the administrative budget approved by the board and parliament, be responsible for the organization and management of the bank. D, cause proper accounts to be kept of all transactions entered into by the bank and of the assets and liabilities of the bank and of valuable entrusted to the bank. Ensure safe custody of the assets of the bank and any valuables entrusted to the bank. And F, ensure the proper discharge of the duties of the staff of the bank and other employees of the bank. So you come to the deputy governor of the bank. That is 161C. There shall be a deputy governor.
Since that is provided in the bill,
Yes.
you will go to your responsibility.
Yes. So my response, thank you very much, Mr. Chair. Our response is simply this, that the clause provides matters of detail relating to the appointment of the governor and deputy governor. The Constitution provides the overall legal framework for several matters, and acts of Parliament specify the detail. It has been legislative practice to provide such matters as provided in Clause 2 in an Act of Parliament, and in this case, the Bank of Uganda Act. You may also recall, Mr. Chairman, in 2005, the Constitution was amended to remove matters of detail relating to the Directorate of Citizenship and the Immigration. Those matters, such as appointment and removal of the director, were inserted in the Citizenship and Immigration Control Act. The rationale for this approach is that it makes it easier to make amendments where there are needs. The needs arise in respect to the governance structure. The overall opinion, Mr. Chairman, is that the matters contained in the bill number 12 of 2020, they need to be further studied, and the rest may be effected in the Bank of Uganda Act. The Constitution Amendment number 2, Bill of 2020 Bill, if you look at the insertion of 32A of the Constitution, Clause 1, 6, to insert this 32A to the Constitution, this requires the Equal Opportunities Commission to submit to Parliament reports on the progress made by the state in regard to steps taken to address affirmative action challenges and the promotion of equitable distribution of employment opportunities for any office. We respond, Mr. Chairman, in that our response is that not a substantive provision that requires the amendment of the Constitution. This is not a substantive provision that requires amendment of the Constitution. Our proposal is that the amendment may, if it is to be maintained, it can be made to the Equal Opportunities Act 2007, and Section 14 of the Act could be amended to provide for the submission of reports to Parliament as one of the functions of the Commission. The section of 86 of the Constitution. This clause 2 seeks to amend Articles 86 to establish election petition tribunals which shall have the jurisdiction to determine the questions relating to whether a person has been validly elected a member of Parliament.
We'll go to the response.
The response is questions as to whether a person has been validly elected a member of Parliament, or whether a seat of Parliament has become vacant, or whether a person has been validly elected Speaker or Deputy Speaker, or has validly vacated such office, are questions that should be considered by a court of law. We will respond further. Our response is that such matters carry serious political ramifications and should be dealt with by the courts and not tribunals. Now, in any case, Mr. Chairman, the cost of establishing tribunals, I'm sure you are familiar with this, is very prohibitive. It is not clear whether there shall be one tribunal or several tribunals. If it is one, then it is a standing tribunal. or only appointed when needed. In practical terms, will it mean that all petitions are heard in the geographical location of the tribunal or not? These are questions that would need to be considered before this thing is done. If there are several tribunals, then the personnel to adjudicate the matters of the tribunal may be a challenge. The court system is the best place to handle questions such as those subject to the proposal. Our proposal is that the status quo should be maintained. We come to Constitution Amendment number 3, Bill 2020, Bill number 20 of 2020. This is the Maragoli which you have discussed already. Insertion of Maragoli in the third schedule to the Constitution. Bill 20 of 2026 to amend the schedule of the Constitution to include the Maragoli as an indigenous community because they settled in Uganda as far as the 19th century. Our response is almost what you have discussed. Our response is that there are several petitions by communities to be incorporated. And if you look at the paper of the Minister of Gender, he mentioned some. There are several petitions by communities to be incorporated in the 5th schedule. We propose that this is dealt with other requests so that this matter is dealt with comprehensively. I want to conclude, Mr. Chairman. My conclusion, Mr. Chairman, is simply that these views on these 3 bills of the Constitution can best be dealt with if you give us an opportunity as a government to establish a constitutional review commission that would comprehensively consider these bills, which will, instead of doing it in piecemeal, and piecemeal will distort the country's constitutional order. Honorable Chairman, I submit.
Did you say what I heard?
No, I didn't see.
That considering bills piecemeal will distort the country's constitutional order. Did you say that?
What I said was,
Okay.
let me say it.
Thank you very much.
I further pray that the committee gives the government an opportunity to review the Constitution comprehensively through the Constitutional Review Commission, rather than considering these bills which will result in piecemeal amendments to the Constitution. Full stop.
Anyway, I think our DNA and Professor Kamuti is the same. So
The document describes in detail the provisions of the bill and makes the following recommendations. It is in light of the above analysis we have made that we make the following recommendation. Number 1, we recommend that opportunity should be given to the comprehensive findings of the studies referred to above to be reflected in the 4 bills, lest the research conducted, which costs time and money, will be of no use. In the report, in the body of the report, we have mentioned the following. Number 2, justification for some of the proposals in the Sexual Offences Bill be provided for further scrutiny through a cumulative process, a consultative process, to ensure that the proposals are comprehensively addressed. Number C, consultation is key part of the legislative process. We entreat Parliament to enable further consultation on this bill. with the relevant stakeholders, namely, you would have really wanted to consult Uganda Police, the Office of the Director of Public Prosecutions, the Ministry of Gender, indeed, Labour and Social Development, and the Judiciary, as well as the National Identification of Persons Authority, to name only a few. Some of these issues for discussion in the consultations include the sex offenders register and the role of police, the judiciary, the Office of the Director of Public Prosecution, and the National Identification of Persons Authority. D, comparative analysis of the provisions of the Sexual Offences Bill 2019 and the Penal Code Amendment Bill 2021. This should be undertaken to ensure that the statute book is not distorted with the duplication of laws which contain nearly similar provisions such as contained in these two bills. E, private member moving the Sexual Offences Bill should work with the ministry to ensure that a bill ensures effective prosecution of sexual offences is enacted. And finally, the processing of the Sexual Offences Bill be halted and an opportunity be given to the minister to process the four bills together as they comprehensively address the issues related to prosecution of sexual offences and to review the laws in force that already address some of the provisions in the Sexual Offences Bill, including the Employment Act 2006, the Anti-Pornography Act 2015, and the Child Act 2019. These were the recommendations which were based on the analysis that is given in the body of the report. Thank you very much, Chairman.
Well, colleagues, I don't know that you have enough time to explore the responses in detail. Or we also want to just ask questions and run out from understanding those responses. Two, we have received the Ministry of Justice response. We study them and we give them another opportunity to come and listen to our views and interact with the community.
Do you want a retreat?
Do you? No, the retreat can only come after we have already interacted with him and sought clarification from what he has said. Because I can see he's so much enthusiastic about pushing everything away. So, well, the Minister, Constitutional Review Commission, in consultation with the stakeholders, because actually it is us who will be consulting the stakeholders anyway, the ones you are talking about. But we will have opportunity to ask in detail, seek clarification in detail. Because time, if we are to be in the House at 2:30, and I'm sure the budget is coming, the supplementary budget.
The Plan Commission.
Yes. So really, we must be in the House within 15 minutes. Do you have any response to that, Honourable Minister?
Where I agree with you, Chairman, is I would like, as much as possible, to conclude most of the pending business in the ministry during the term of this Parliament, if I can do it. Consequently, every minute counts. I would therefore be willing to come back and provide a response when you are ready, sir.
Okay, is it also your response that the Constitution Review Commission will be in place before this term of Parliament ends?
I can tell you, if there were no consultation to be made, I would table. I would have this constitution. Yes, sir.
Yes or no?
Will the Constitutional Review Commission be in place before the term of this Parliament ends?
Is it feasible?
We'll ask you.
Well, I'm seeking your opinion, Chairperson. If it was feasible, it would be done.
It is now 8 years.
Honorable Chair, can I ask for clarification from Honorable
Sure.
Minister? Thank you, Honorable Chair. Honorable Minister,
Are you aware that the issues that are contained in the sexual offences bill have been under consultations for the last 40 years? Are you also aware that there is nothing to stop government from working on these 4 bills, as you said, but government failed, and that's why the private member had to come in. So how can you say allow government? Who has stopped you from doing your work? Thank you.
Just a question to you, Honorable Minister. Our names may be a little bit similar, but you can answer the question.
No, thank you. Only that, of course, as private members, you have every right to introduce a private member's bill anytime. And the ministry's position is to work with any private member that has a bill so that the bill, when it is enacted, is consistent with the existing legal framework. And the ministry has the technical capacity to help in this regard. It is also compelled by the law to cooperate with the private members. Now, yes, it is true, sometimes the bureaucracy of government is slow. That I admit. But there is political will to have things done on time. Thank you.
Will you have opportunity to consult with this committee and you come up with this off record, and you come up with the possible members of Constitutional Review Commission? I don't want to consult you in your office about this. People have heard about the need to amend the Constitution. Some are here, and this committee would be very helpful. I know as a professor, you know what I'm talking about.
No, I can't confirm.
Well, the question was not on record, and I imagine we don't need this an answer on record.
No, I can also say off record that as I'm talking to you right now, there is two-pronged approach to this. Work had already been done to the point of going to cabinet, and what held it up was a certificate of financial implications to take it to cabinet. And the budget proposed was something like 18 billion. And the Minister of Finance was not in a position to do it. I have reviewed it, this time off record again, to the presidential level for his intervention, because we really want this thing to be done. And I'm waiting for his response, just for his intervention to tell the Minister of Finance to do something. The Minister of Finance on his own said they have no money. Off record again.
There is no circumstance where Minister of Finance will say that they have money. That is the standard thing that we have no money. So it depends on how you push them. Anyway, colleagues, I would like to thank the Minister for the presentation. It's unfortunate that we started late, therefore we can't accomplish what we thought we would do today. With the permission from the committee chair, I think we can have, depending on his diary, next week, or when the minister can come and we interact with him about his responses.